Hi everyone, my name is Abby Worden. I'm an associate attorney here at Lockerbie PLLC in Lexington, Kentucky, and today we're going to be talking about Fair Credit Reporting Act, or FCRA, and how new Clean Slate laws and ban the box laws are reshaping background checks and criminal history screenings and hiring. First, let's start at the beginning. The FCRA is a federal law that's been around since 1970. It was originally designed to protect consumer personal information, but over time it's grown to include background checks. If you use a third-party company to run your background checks, you're using what's called a consumer report, and that means the FCRA applies to you. So under the law, employers must do three things. First, you have to get written consent to run a background check. Then you have to provide clear disclosures about how the information is going to be used. And finally, you have to give candidates a report and a pre-adverse action notice before making any negative decision based on their background check. So that last part is critical. Employers can't just see something on a report and then deny an applicant. You have to give the person a chance to review and respond. In recent years, federal, state, and local governments have added more layers to this process. Ban the box and Clean Slate laws are changing what employers can ask, when they can ask it, and what information they can consider. Philadelphia's Ban the Box Amendment, which is effective January 6, 2026, limits the look-back period to 4 years for misdemeanors and excludes summary offenses altogether. So expunged or sealed records can't be considered even if they appear in the report. Additionally, Washington, D.C., California, and Minneapolis have passed similar fair chance reforms, each requiring more transparency, individualized assessments, and written notice before taking any adverse action. These updates reflect a national trend towards rehabilitation-focused hiring and privacy-conscious data use. For employers, the takeaway is simple. You need to re-examine your screening workflows. This means reviewing when in the process background checks are ordered, making sure that your consent and disclosure forms meet both FCRA and state law requirements, and double-checking that your vendors are compliant and up-to-date on local rules. Even well-intentioned employers can trip up on timing or notice requirements, and that's where we tend to see lawsuits start. More than a dozen states have now passed Clean Slate laws, which automatically seal or expunge certain criminal records after a period of good behavior. So for employers, this means older sealed convictions may not appear on a report, or if they do, they must be ignored. This functions as another reminder that background screening isn't static. The information that you receive and how you're allowed to use it can change from year to year. The big picture is fair hiring today means balancing safety, compliance, and second chances. If your hiring process involves background checks, now is the time to review your procedures, your forms, vendors, and internal decision-making steps to make sure they all align with the FCRA and fair chance laws. If you found this video helpful or felt like you learned something, give us a like and subscribe, and we'll see you next time.